Can you sell a home before probate ends in Florida? The short answer is yes. But if you skip this before you list, you could end up under contract on a property you are not legally allowed to sell, lose your buyer, add months to an already long process, and drain the estate with the carrying costs the whole time. Let's start with the direct answer. Yes, in many cases, you can sell a probate property in Florida before probate is fully completed. In Florida, the person who manages the estate is called the personal representative. If you've heard the term executor, it's the same role. Florida just uses different terminology. The personal representative gets their legal authority from the court through a document called Letters of Administration. Once a personal representative is officially appointed, you can often sell the property before probate ends. But there is one key condition. The personal representative must have authority to sell. That authority is called power of sale. It comes either from the will or from the court if the will doesn't include it. Once power of sale is confirmed, the personal representative can work with a real estate agent, market the property, negotiate a contract, and move forward toward closing, all while probate is still open. So step one is always confirm with your probate attorney that power of sale is in place. That one conversation can save a lot of stress. Even when selling is generally allowed, there are situations where the sale still requires court approval before it can move forward. 3 common scenarios. Scenario 1, when there is no will. If the person passed away without a will, what Florida calls dying intestate, the court takes on more oversight. Selling the property requires a separate court authorization before title can transfer. Scenario 2, when power of sale wasn't granted. Some wills appoint a personal representative, don't explicitly include a power of sale clause. In that case, the personal representative can still pursue a sale, but the court must authorize it before title can pass. Scenario 3, when the authority is limited or conditional. Some wills include conditions such as sell only if the estate needs funds to pay debts, or only after a certain period of time. If those conditions exist, they have to be addressed before any sale can happen. Why does this matter? Because if you find out mid-process that court approval is required, after you already have a buyer waiting, that's when families lose deals and carrying costs pile up. In a court-supervised sale, here's how it typically works. You list the property, get it under contract, then petition the court to approve the sale. The court sets a hearing, verifies the sale is in the estate's best interest, and issues an order authorizing closing. This adds time, typically several weeks, but it is not the roadblock most families fear. A good probate attorney and a real estate agent who knows the process can keep things moving efficiently. My name is Michelle Miller. I'm a licensed real estate agent in Lee County, Florida, and I hold a certified probate expert designation. Probate attorneys handle the legal process. My role sits right at the intersection of where that legal process ends and the practical property decisions begin. I help personal representatives and families understand what their options actually are and what those options mean for the property. Nothing in this video is legal advice, just a practical overview of how this typically works. If you find content like this helpful, consider subscribing. I make videos specifically for Florida probate families, personal representatives, heirs, and out-of-state families managing a Florida property from hundreds of miles away. Now, here's the section that trips up a lot of families, even when everything else seems straightforward. Florida's homestead law. Florida has some of the strongest homestead protections in the country. And when a property qualifies as a Florida homestead, meaning it was the deceased person's primary residence, those protections can step in and directly affect what can be done with it during probate. Here's the part that surprises people most. Even if the will clearly says the house should be sold, Florida law steps in and affects who actually has rights to that property, and that directly affects whether a sale can move forward. Here's a scenario that illustrates this well. A father passes away. His will names his adult son as the personal representative, with instructions to sell the house. Seems straightforward, right? But there's also a stepmother, the father's second wife, still living in that home. Florida homestead law gives that surviving spouse rights that attach to the property automatically, independent of what the will says. Those rights affect who has ownership interest in the property, and that directly affects whether the personal representative can simply proceed with a sale. In many cases, ownership itself needs to be formally determined first, and all affected parties may need to be part of the decision. The same principle applies differently when there are minor children and no surviving spouse. In that situation, Florida law restricts how the homestead can be transferred through the will entirely. The will's instructions don't control. This isn't a loophole or an edge case. It applies to a significant numbers of estates in Lee County, where many families own primary residences that have been in place for years and where blended families are common. If there's any possibility the property is a Florida homestead, that conversation with the attorney is not optional, and it needs to happen before you list, not after you have a buyer waiting. One more thing worth mentioning. Even when a sale is allowed and the personal representative has full authority, in practice, many probate attorneys still prefer to review or sign off on the sale. So you may hear different answers depending on who you talk to, which is exactly why it is always best to confirm directly with the attorney on your specific case, rather than relying on general guidance, including this video. If you have a Florida probate property right now, and you are not sure what your options are, I'm happy to talk it through with you. There is a link in the description to book a non-pressure call, no obligation, just a conversation to help you understand where things stand and what makes sense for your situation. So to bring this full circle, when you started this video, you may have assumed you had to wait until probate was finished before you could do anything with the property. Now you know the answer is yes, with the right authority in place. Probate has rules, but it also has options, and the families who navigate it best are the ones who got clear information early, before they had a buyer at the table and no answers ready. One last thing before I go. I'm still building out this channel, and I want to make sure I'm covering what actually matters to you. So drop a comment and let me know. What's the one question about Florida probate you wish someone would just clearly answer? I read every comment, and your questions directly shape what I cover next. See you in the next video.